Okay, and thank you all for coming. My name is Sandy Baird, and I am a part of the Vermont Institute of Community and International Involvement. And I'm here tonight to talk to you a little bit about what I think are the most important issues facing us in the United States today, and that is the violations of our Constitution and our Bill of Rights. The Bill of Rights distinguishes, I believe, the United States from all other countries on the globe. They are outlined rights from the government, and we must understand that. There are very few people, very few countries in the world that operate with liberty from the government. And those restrictions that most governments place on people's rights are to do with free speech, are to do with the right to assemble, the right to petition our government, the right to worship as we please or not, as we also may please not to do. All those rights are freedom from government interference in those basic rights. And today, I believe that this is the most important rights that have been challenged by the United States. And this, to me, are the important election issues also. To me, it's not a difference between the Republicans or the Democrats. To me, the difference that we face is between our right to remain free people under our Bill of Rights and our rights to be government controlled in those rights. So tonight we have a very important case that has been filed on behalf of a group of students at UVM. Those students were called Students for Justice in Palestine, and they were rather summarily suspended from being on campus, and I guess they have not been reinstated. And it's very unclear to me why they were suspended, why they have not been reinstated. And it has at least something to do with their rights to speak. And those rights have been denied by the University of Vermont. We have with us tonight to discuss that issue a free speech expert, two of them, as a matter of fact. One of them, an old colleague of mine. I mean that in terms of the years we've been colleagues.
Both are true. Both are true.
Right, and also true. And that is John Franco, Esquire, who is with us tonight because he filed suit against UVM. And I want him here tonight to explain to you why that suit is happening and what the rights of those students, how they have been impinged upon, and whether or not we are going to be successful in forcing the university in a way to give the students the right to be on campus again. Those students were, as I said, Students for Justice in Palestine. I might remind us all, if we watch Amy Goodman on a regular basis, that these student protesters protesting basically to end the very serious war that's occurring right now between Israel and in Gaza and now in Lebanon. That those students who are protesting that war are being shut down all over the United States, not just at UVM, but all over. To me, it is a serious change in university behavior. I was part, as many of us were here, part of the anti-Vietnam War protests that occurred in my university many years ago at the University of Wisconsin. We were all treated badly, but in the end, we were all allowed to protest. Those rights are being seriously challenged all over the United States. This, to me, though, is the first lawsuit, the federal lawsuit, that has been filed on behalf of those students, particularly those students for Justice in Palestine. I think that they're a national group, aren't they? Have you discussed that?
It's the second suit that's been filed.
The second suit, the University of Maryland, right?
No, Florida.
No?
Florida.
Florida.
I'll get into that.
Okay. Anyway, so here's John Franco. I might mention that John Franco was the first city attorney for Bernie Sanders many, many years ago when he became mayor. The second speaker will be Jared Carter, who is also a lawyer, and he's a professor here at Vermont Law School, and he is a constitutional scholar, right, Jared, I guess?
Of sorts.
And he's an old colleague, younger colleague, but many years colleague of mine also. So here's John.
Okay, let me start out by, I got a lot to cover, to try to give you what the general background of the suspension was. In the spring, Elise Stefanik and the Republicans in Congress summoned a number of presidents of universities before them to dress them down, to bully them, because they were not cracking down sufficiently on the pro-Palestinian protesters. And in particular, the president of, now the former president of Columbia, By the way, all the ones who were fired at were women. If you haven't noticed that, the 4 ones that they were all women. Went back and cracked down on the encampment at Columbia. That sparked a nationwide reaction on college campuses that started around the last weekend of April. And that was also the case here at UVM. UVM Students for Justice in Palestine were one of a number of student groups and individuals who put together a protest at UVM in the so-called Harris Commons, Andrew Harris Commons, which is the big area between the library, the Morrill Hall, the New Davis Center, the Life Science Building. The old days, the center of the campus used to be the green, but now that's really more the center of activity. And so one of the sins they committed was erecting some tents as part of an encampment, as part of the protest, and they did this, heaven forbid, on a rainy Sunday afternoon on the 28th of April, when 3 of Vermont ski areas were still open, because it's still, a good part of the state, still winter. 3 days later, the university issued Students for Justice in Palestine an order suspending them as a university student group for kind of general, you are bad people who are a threat to our students, our staff, and our visitors, and you're therefore suspended. We have reason to believe that you're bad people, and you're suspended pending our investigation into whether or not you're bad people. And that occurred on May 1st. May 1st was also a very interesting day. That was the day when Governor Sununu sent armed goons to Dartmouth to brutally suppress the peaceful demonstration that occurred on the Dartmouth Green that day, which included seriously injuring a history and a late 60-year-old history and labor professor there who actually lives in Vermont. And those kinds of crackdowns also occurred about the same day. The protest at UVM went on for about 10 days. It ended around the 7th or 8th of May. They voluntarily disbanded the encampment. It was by all accounts peaceful. They had trained their participants in nonviolence. They had people trained in de-escalation because there were pro-Israeli demonstrators that showed up and counter-demonstrated at the same site. There was no violence there at all. Unlike, by the way, UCLA. Let's talk about UCLA for a minute. What they did at UCLA is the pro-Israeli demonstrators physically attacked the Palestinian demonstrators with sticks and bats, and I don't know if there weren't any guns, but spears.
Chemicals.
And chemicals, and as a result, most recently, the university, the UCLA got sued by pro-Israeli groups under Title VI for not being sufficiently aggressive against the Palestinian student protesters. Not a whiff of the fact that this attack on the Palestinian pro-Palestinian students went on for 3 hours with the police literally looking the other way, which is exactly what happened in Germany and under Kristallnacht in the 1930s. I mean, it's tried and true. It's what happened in the South when you had the Klan beat up and lynch African Americans. If I was to say that this ban had much of a practical effect during the balance of the protests, it probably wouldn't be true. I don't think the members of SJP did a whole lot to censor themselves. And then, they disbanded around May 8th. It was when classes ended and exams started, and UVM graduated the week after that. And then you had the summer session. And during that period of time, right in May, this suspension notice was brought to my attention through the student's faculty advisor, Helen Scott, who had been in contact with Barbie Prine and some other attorneys in Burlington, and said, you need to look at this. I saw the suspension notice that they got, and I was appalled. I was appalled. I don't know if any of you remember the Pentagon Papers case in 1971, where the U.S. Supreme Court struck down the Nixon administration's efforts to censor the publication of the Pentagon Papers by the New York Times and the Washington Post. And the U.S. Supreme Court said you can't do that. It's a prior restraint of protected First Amendment speech. That is exactly what UVM did. You've got to be kidding me. This is one of the most famous civil liberties cases in the history of the United States. New York Times versus the United States. I mean, and they were prosecuted under the Espionage Act. And that what UVM has done here is a prior restraint of this group's entire spectrum of First Amendment rights on campus. The only thing they can meet about is to address the investigation that the university is supposedly doing. Now, I want to get to the investigation part for a bit. They said in their order that the suspension was in effect while they had these allegations or these suspicions under investigation. Their procedures, the student disciplinary procedures say, and and let me stop there for a minute. That's out of Alice in Wonderland. First you get the sentence and then you get the evidence afterward. That's not what we have in the United States. And so they're saying you're suspended until we investigate whether it's true. Well, it can't work. It can't possibly work that way. The other thing that happened is they said, well, we will do the investigation promptly. Well, people were on vacation. It was June and July, and August came around, and I said to Helen Scott, I said, well, what's the status with the suspension? I mean, class is going to resume in August. So we contacted the woman who's one of the defendants, Linda Balcom, who's the director of Student Life, who actually was the one under the rules who made the decision to do the suspension. And we said, we wanted to meet with them informally to talk with them about how messed up the suspension order was constitutionally. We asked, this is a little biblical, we asked and were denied 3 times. We asked, and finally we sent a letter, and we said, and they said, well, you've got to go through the student process. Oh, this is the student process they have. At least in Russia, they put you in a cage and give you a lawyer. They give you a lawyer, but they put you in a cage. Here, what they do, if you're a student, you either have to go in through their administrative process and admit your guilt, get on bended knee, and then ask for their clemency for what you did, or you have to go through the investigation process, but there's a catch. If you're an undergraduate student facing the entire administrative apparatus of the University of Vermont, including all their lawyers, you cannot be present with a student advisor, with a faculty advisor, and you cannot have an attorney. You cannot have an attorney. That's a fair process. So I said to Helen, I said, if you think I'm going to send my clients in front of them without counsel, you're out of your cotton picking mind. And so we wrote to the university's counsel. We said, we're not going to go to that without counsel. You're out of your cotton picking mind. You're not going to do it. Well, those are the procedures, and those are what you have to follow. And so then we began to work in earnest, putting together the lawsuit. Part of what we did is not only pointing out the complete unconstitutionality of this prior suspension of this group, but the flaws. The university's reasoning is, they said this in a press release, we believe in free speech as long as you follow our rules and procedures. That is classic. That's classic. You know why they got their heads beat in at the Pettus Bridge in Selma, Alabama in 1965? For marching without a permit. You know why they got fire hosed in Birmingham, Alabama in 1963 by Bo Connor for protesting without a permit? In fact, the language of the notice of violation that they used against UVM SJP was almost verbatim out of the ordinance that Birmingham, Alabama had in 1963 that they used for prosecuting those protesters and sentencing them to hard labor, I might add. I don't know that they did it consciously, but this is the lineage that the repression comes from. There are a ton of civil liberties cases, not the least of which was called Shuttlesworth versus City of Alabama. It was the second time that protest case went to the U.S. Supreme Court. That was decided in 1969, and they said, if you have time, place, and manner restrictions like this, you cannot have these blanket exceptions that say, but we can prohibit the demonstration if we determine that it's going to be dangerous to public morals or public order, or be, what did they? Well, I'll give you some of the things that they said here. Just a second, I got to find it. This is just too good. Oh, here we go. This is good. The University of Vermont is suspending all operations of SJP on an interim basis effective immediately. We are taking this action because of the continuation of concerning behavior. Mind you, concerning behavior, everybody. Look out for concerning behavior. Sandy, your concerning behavior. Your behavior has always been concerning. I used to get beat up in her house for that, but anyway, we won't get into that.
Please.
And encouraging, mind you, this is Latin, horribile dictu, horrible to say, willful violation of university policies for repeated notice and requests to cease. These actions have had a direct impact on the safety of students and university operations. Interim suspension is appropriate in circumstances where, as in this case, preliminary evidence demonstrates that an organization's activity may pose a threat to the health, safety, and well-being of persons within the university community and our guests. There you have it. Read Bull Connor, Commissioner of Public Safety, Birmingham, Alabama, 1963. Thank you, Bull. That's where that kind of thinking came from. It's as old as time. The Shuttlesworth case talked about how that's as old as time. You can't do that. And when you have that, you have a sham. And what we did is we said, aha, okay. So they suspended SJP. Has there ever been another case where they have suspended anybody for protected activity? As far as we can tell, the answer to that is no. Never has happened. And I went to UVM and we did some stuff, and it was a lot more disruptive than this. And let me give you let me read some what we did, some of the research I did and found out. And by the way, the newspaper of record about what goes on at UVM for protests is the student newspaper, the Vermont Cynic. Absolutely have the best coverage of what was going on.
You did?
Oh yeah, they really did a good job. In fact, the nice thing about it, I'll give you a little issue about the rules of evidence. The Vermont Cynic is a publication of the University of Vermont, and it's published on the internet. Therefore, it's a government publication. It means I can just use anything they say in a court of law because it's the equivalent of a government publication. Nah, 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 nah. Let me see here. Hang on, I got to find it. Oh, yes. Oh, yes, this is the good stuff. Previous protests, September 17th, 2017. 200 students marched into the Waterman Building to the UVM President's office with a list of demands regarding racial disparity in the university. Participating organizations for the Black Student Union, I don't know if I pronounce this correctly, Alianza Latinx, and the Asian Student Union. To our knowledge, no disciplinary action. February 20th to 23rd, 2018. A group of students called No Names for Justice held various demonstrations regarding racial injustice on campus. They took over classrooms. They blocked traffic on Main Street by the Davis Center at rush hour, which, by the way, is an access to a tertiary care medical facility. They marched to the Waterman Building along with Black Lives Matter and occupied the atrium area inside the building for 10 hours. As far as we know, no student disciplinary action, no suspension. This is a good one. February 26, 2019, No Names for Justice held another rally, this is a year later, inside the atrium of the UVM Waterman Building to mark the one-year anniversary of the so-called Waterman occupation for the year before. And I'll get to you in a minute why that happened. September 20th, 2019. Hundreds of students walk out of classes at 11 a.m. To strike and attend a strike rally at the Andrew Harris Commons, same Commons, to protest inaction on climate change. Participating groups included VPIRG, the Sunrise Movement, Climate Communications Advocacy, and the Literacy Laboratory, 3 days later, September 23rd, 2019, same group of students, which called themselves the Extinction Rebellion BVT, blocked traffic on Main Street, again by Davis Center, during rush hour to protest inaction on climate change. Again, blocking vehicular access to a tertiary care medical facility. No action taken. February 18th, 2021, a group of #MeToo students staged a protest of UVM's admitted students visiting day to protest UVM's response to allegations of sexual assault on campus, particularly on the part of members of its athletic teams. This complaint, sexual assault, by the way, now is in federal court in a case called Ware versus UVM, which is being heard by the same judge that has our case here, by the way. 200 to 300 students congregated at the Andrew Harris Commons and proceeded through the Davis Center marching and chanting, and obviously disrupting things, right? No action was taken. May 3rd, 2021. Thousands of students gathered at the Redstone Green to again protest UVM's alleged complicity in sexual assault. They blocked traffic while they marched to the UVM Green and then the Waterman Building. They held a protest rally on the steps of the building, which spilled over onto the adjoining South Prospect Street and the UVM Green, again blocking traffic. No action taken. And finally, my favorite, an oldie but goodie, pre-marijuana legalization in Vermont, the 420 protests, April 20th protests, on the, I believe it was the Simpson Green down on the South Campus, for smoke in and practice every day annually on 420, which is also Hitler's birthday. So the only one of these involved, that I could tell from my research, that involved any kind of sanction was the ones that had the anniversary protest in the atrium of the Waterman Building. And there were individual student disciplinary actions that were brought at that time. And the claim was that they were in the atrium with bullhorns having this rally, and if you're in the atrium, it's inside a building, it's very noisy. And they said that was not an appropriate venue, and there were better venues to hold that elsewhere on the campus. Now, here's the reason, and I'll get to what one of their protest conditions is. One of their protest conditions is, if you're a student and you want to get a permit for a protest, you have to sign away your personal liability for the damages for anything that happens. Well, the Black Student Union was going to hold this commemoration in the Memorial Auditorium of Waterman, and they required the Black Student Unions to sign on the dotted lines that said that they would be responsible for any ensuing damages. The Black Student Union told them where to shove it, and they went and had the thing out without a permit on the atrium. So that shows you the logic of the various permitting procedures that they have. Now, of all the things that were done at the university during this protest, the only one that was not presumptively protected constitutionally was sleeping in the tents. Okay, the U.S. Supreme Court, in its infinite wisdom, in a case in 1994 called Clark versus Citizens for Creative Nonviolence, it involved a encampment protest in Lafayette Park, which is across from the White House. And it was the National Park Service brought in enforcement action. And the upshot of it is the Supreme Court said, putting up tents is a very powerful form of symbolic speech, but sleeping in tents isn't. So the bottom line of what the university should have done, rather than weaponizing the permit requirements at this protest, have simply said, look, everything you're doing here is presumptively protected under the Constitution. We're giving you a permit. We're giving you a permit here. Back of their no trespassing. Permit granted. The only thing you can't do is you can't sleep in the tents overnight. If you do that, you do it at your own risk. And then the students would have make an informed decision about what their risks were. They didn't do that. They didn't do that. They went around and weaponized. Well, you're violating our procedures. You don't have permits. You don't have this. You don't have that. And unless you toe the line, the wrath of God is going to come down on you. And that's what they did. And then they went after these students individually. The interesting thing about the individual students is every single one of those cases that was contested, there were some students who said, look, I'm going to graduate. I don't want to hold up my degree. I'm going to go through the administrative process. I get a slap on the wrist and win. The ones who contested it, there was not a single student who contested who was found responsible or found had violated the student policy. And part of the findings that they had, they said, number one, protesting doesn't violate the facilities use policy, which is one of the things that they were claimed to have violated. The facility use policy doesn't apply to the green of the Andrew Harris Commons. It only applies to internal facilities, buildings, and things like that. And they also said, in terms of the big thing was, well, we told you to we told you to remove the tents, and you didn't remove the tents. And they said, well, those are other people's tents, and you don't have any power over the other people. The university had to find out whose tents they were and give them an order, and they didn't do that. So that individual effort all collapsed. But one of the things we also have attacked here in this lawsuit is how, and really drawing a line right directly to the types of repressions that have occurred throughout the country involving protests, is that their policies at critical junctures give unbridled discretion to people like Michael Sherling of University Security, particularly for their tenting policy. Their facilities use policy says protests, they told the students that they had to get permits under their facilities use policies. That's not what the facility use policy says. The facility use policy says protests are under the jurisdiction of the dean of students. You know what the standards are for the dean of students, whether to grant a permit for protesting? There aren't any. None. Bill Connor, once again, none. Then you have the contradiction between that and their display policy, display it's their temporary structures policy. The temporary structures policy said temporary structures can be allowed unless Michael Sherling thinks that they're a danger, and then if they go into the bureaucracy about being permitted for a facility, then there's another catch-all that says it still may be denied if we think it's bad or think it's going to be a problem. In all the cases that have dealt with these that have been decided by the federal court, say that kind of blanket discretion is just not permitted because it gives you the ability to pick and choose who can protest and who can't, based upon the content of the message. And so then this is what's really good. For those of you who don't know the law, I will give you this little diversion. We live in what's called the Second Circuit. Federal appeals courts are divided into circuits. We are the federal appeals court, we're in the Second Circuit. The Second Circuit is Vermont, Connecticut, New York. And there's a wonderful decision out of the Second Circuit called McDonald versus Shafir, who was the head of the Parks Department in New York City, that said that when you have a wide open ability of the municipality or whoever's granting the permit to deny a permit because bad things might happen, that's unconstitutional unless you can point to a past administrative practice and definitive administrative policies which lay out, in fact, in practice, when these permits will be granted and when they'll be denied. And that's where all these prior protests, which have occurred at UVM where they didn't do a cotton picking thing, come into play. They can't show by past practice that this was anything other than a content-based discrimination, that protesting in favor of Palestinians and against Gaza is taboo. Climate change isn't taboo. Racial equity isn't taboo. Me Too isn't taboo. This is taboo. This is taboo. That is basically what we think this shows. Let me go through some of the things we're attacking here. First of all, we said in 2 counts, we don't care what they did, maybe short of firebombing the university, cannot suspend somebody's on a prior restraint basis a group's constitutional rights. You just can't do that. And some of the cases we had were really good ones. There was one 1 year after the Pentagon Papers case was called, was it Healy versus James? And that involved a case where, I forgot the name of the cause, they tried to prevent Students for Democratic Society being recognized as a student organization because they were bad, because they were extreme leftists, blah, 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 blah. The Supreme Court said, no, you can't do that. That involves suspending a student organization, denies them access to all the university facilities and their ability to meet, to associate, to protest, to demonstrate. Then there was another one that was a little bit later, 2 years later. It's probably one of the first gay student demonstrations in the United States, 1974. It was a gay student union of the University of New Hampshire that was not recognized as a student group. And the Court of Appeals, not Court of Appeals, the U.S. District Court in New Hampshire said, you've got to recognize them. You can't withhold student recognition for a gay student group. I mean, this is protected First Amendment activity. And some of the other ones that have happened after that, there was another case involving an anti-Islam protest by the young college Republicans in some college in, I think it was San Francisco. And the college tried to suspend their status as a student organization. And again, the district court and the federal district court in California said you can't do that. Even if some people consider the speech to be horrific, you can't do that. It's just not permitted. And so that just really undermines the argument that, well, I don't know what UVM could argue that SJP was doing that would justify the breadth of this prior restraint. I mean, think about what this means. They can't talk about the presidential election. They can't talk about state elections. They can't talk about legislative elections. They can't talk about city policy. They can't talk about homelessness in Burlington. They can't talk about the mayor. They can't talk about anything except the investigation they're under. That's the breadth. That's the breadth of this order. Are you kidding me? I mean, you think this is a Latin American military junta that just outlawed, political parties, which is really, this is also the lineage of this kind of an order. The protests and demonstrations, I kind of touched on that. What they were handing out to the students that they said it violated the facilities used for events and activities, and they had to go get permits, that was wrong, because it specifically provides that demonstrations are subject to the jurisdiction of the dean, and there's no standards for that. Some other problems. The prior registration things. You have to prior register. You have to sign on the dotted line that you're going to be liable. Those things have all been thrown out in the past. The tents. Lots of case law in the federal courts after the Occupy movement have said, sorry, folks, tents are protected symbolic speech. You have to accommodate them. They got all in a pinch because of the tents. They were just dead wrong about that. I mean, there's some of the most wonderful cases out of states, you'd never believe it. U.S. District Court in Idaho, it's Waters' case, and they were protesting on, I forgot where it was, but they said what the Idaho court said at the end. Look, at everything they're doing is protected, with the exception of sleeping in the tents overnight. That's not protected constitutionally. However, they said you can have enough people there overnight to watch things to make sure that they're not destroyed or stolen. The other fun case was called Occupy Columbia versus Haley. Now, it was not Columbia University, it's Columbia, South Carolina. And Haley was Nikki Haley, and it involved an Occupy activities and encampment on the State House grounds in South Carolina, and that federal court just gave them a run for their money on that. I mean, they just said, what are you doing? They were busy. And it's great wisdom. The South Carolina legislature banned tinting expressions that specifically dealt with this form of protest. I mean, it was content-based. It was just wonderful. And another really good one involved the city of New Haven, Connecticut, that involved an Occupy movement in the New Haven Green. I mean, that has some really good precedents that we can use, not the least of which they said you have to look at whether or not there was an administrative precedent which show that the city of New Haven was exercising some very strict and specific guidelines as to whether or not the activity would be granted or not. And they said in that case that they had those guidelines and those guidelines had been followed. They also, and that's going to really hurt UVM because it says you look for their past administrative practice, which the UVM can't show. And the other beautiful thing in that case is they pointed out, they said, look, just because you don't allow the tents here, well, you've got to provide alternative time, place, or effective time, place, or manner alternatives. You've got to give them tenting place over there. And what they did at the end of the decision, even though the poor city of New Haven, they march down, think they're at the goal line, they're going to win, and the judge says, now I expect you to go meet and confer, and I'm sure when you meet and confer, you will work out places where this protest will be allowed to the satisfaction of both parties. Now get the hell out of here. And that's what we tried to do with UVM in July and August. I had read these cases, these meetings. I wanted to meet and confer with them and said, what are you doing? You can't do this. So one of the things we're arguing here is about the tents. Look, folks, if you don't like the tents on this little part of the Andrew Harris Commons, you've got to move them over to another part of the camp. Or you can move them down to UVM Green. You don't like them, you can move them down to the UVM Green. You've got to allow an alternative means of an effective means of engaging in that collective action, that concerted action, the right to assemble, and the right to speak symbolically. You can't just be like Michael Sherling and say no. Go ahead.
Okay, well, Jared, were you?
Yeah, I mean, I don't have a specific presentation prepared per se. Obviously, it's Attorney Franco's case, but I guess I would love to sort of suss out some of the things that you pointed out.
Suss out?
Yeah, suss out. You ever heard that word?
Yeah, then I'll get into my ex parte young.
Put it in a brief. It's a good word. So I guess one of the things that come to mind is. So certainly under the First Amendment and a lot of the cases that you cited here, and I think in the materials as well, a university can't engage in content discrimination. In other words, picking winners and losers in terms of messages.
Right.
But can't universities pass and enforce regulations that prohibit disruption of campus events? And did they make that assertion here? And how does that sort of fit together?
They made that assertion, but the problem, the other classic case, 1969, the Vietnam War black armband case, Tinker versus Des Moines, said, well, you can keep in mind this is not a college, this is a high school, secondary school. You know, you have a right to maintain order, but you've really got to show, you've got a really high burden to show that it was actually disruptive. And what they've done in the university cases, they said, the Healy case said, hello? After Kent State, we just lowered the age of majority. Remember that? And the voting age is down, and you can contract now. These are adults. In local parentis is going to, local parentis used to be colleges acted in the place of parents. That's gone. UVM doesn't think that that's gone, but that's gone. And so now, and what you have now is not only you have adults that are going to your college, you have adults that are paying over $100,000 to go to your college. They're your customers. This is how you're treating your customers. I mean, whew.
So, but your question was, what was?
No, I think he got at it. I guess I'm trying. Where do you draw that line from sort of First Amendment perspective as to when does something become disruptive and therefore can be regulated, prohibited, versus expressive conduct? Because it seems like that's really the rub here, right? The First Amendment protects speech. Right? It doesn't say anything about conduct in the First Amendment.
No, it's conduct.
The courts have, of course, interpreted that to include expressive conduct. So conduct that speaks is protected under the First Amendment. But how do you sort of see that?
Symbolic speech is all the tense are symbolic. Tense are a form of speech. And the answer, and Mr. Answer Man is going to come with the answer. The answer is that, hang on a second. That the university has a very high burden, a very extremely high burden to prove that this was actually disruptive. That people don't like the content of your message is not disruptive.
Right. That
you've got tents out there where there normally aren't tents out there, that's not disruptive. That's just not going to meet the standard. I mean, again, what happened in the Pentagon Papers case, they were in violation of the Espionage Act. But I mean, Ellsberg figured he was going to go to prison for a very long time. And he would have if they hadn't broken into his psychiatrist's office, but that's another story. To justify a suspension, the act's complainant must materially and substantially disrupt the work and discipline of the school. Materially and substantially. The record must show a substantial basis for the conclusion and not be based upon surmise and speculation. And so that's, you really got to show a lot. I mean, if they were running, for example, they were running through classes and they were really disrupting classes, which happened with some of these other protests, then I think they would have something to argue about. And there's another thing that's referred to as a heckler's veto. If somebody else is speaking and you go and you disrupt the speech, that's not protected activity. Actually, in Vermont law, that's a form of disorderly conduct. That's a criminal violation. That case is called State versus Stacy.
Do you have other questions, or maybe we could open it up to the audience as well? But so there's no basis, therefore, none whatsoever, to suspend students for justice. In Palestine, what did they do? Nothing. Did they do anything to disrupt?
Well, even if they told students, screw it, sleep in the tents overnight, that's not a grounds to suspend their First Amendment rights. It just isn't.
But this is also an organization.
Well, that's the other problem is the organization didn't sleep overnight. The organization didn't own any tents.
So how?
And that's why the individuals who they brought in on these charges were acquitted because they couldn't show. But Logan Pruitt, who was the spokesperson for SJP, one of the charges they had was, he was sleeping overnight because he was sitting in an Adirondack chair in a sleeping bag in the morning, and he said, it was cold.
Yeah, but you said that they suspended the organization. How on earth do they justify that? It has not been reinstated, correct?
I read you the justification they made that we have information and belief that you're bad people.
Bad people? No, they didn't say bad.
Look at the etymology of this is Robespierre and the Committee of Public Safety in the French Revolution.
Right.
What was Beria the head of in the Soviet Union? The organization of state security is always framed in terms of safety. Safety to our students, safety to our staff, safety to this, safety to that.
But there was, as far as I can tell from everything you said, there wasn't one action that this society or student organization took to indicate that it was unsafe, or there's no actions that they took. Did they take any action?
This, compared to the other protests that occurred, this was a very, frankly,
Nothing. So
what do you-
there's a very, 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 very peaceful, non-disruptive event. I mean, unbelievable. Unbelievable that they picked out this one compared to all the other ones that have occurred,
Oh, well,
including 420. I mean, my God. The whole green was levitating from the marijuana smoke, which was illegal at the time.
Which kind of prohibits action a lot, anyway, right? Okay, Musa.
Oh. Is anybody checking on who's behind all of these, working with universities? What we know is Jonathan Greenblatt, I'll mention him by name, of the ADL, has
See
been
ADL, though, from people who don't know, what's ADL?
Right, Anti-Defamation League.
Right.
And they have been very active in collaborating universities in doing the wrong thing. And is that, being discussed or checked, or, how they are connected with the university here and others?
Well, if you guys want to fundraise $1 million so we could do the discovery on this, yeah, I mean, that's something we might be able to find out. I mean, I think you can kind of, I think inferentially it's very clear. What we mentioned in the complaint was the cancellation of the Palestinian poet, and it turned out, based upon a public records request by 7 days, they had nothing. It was just Michael Sherling that just decided to shut him down. And I think it was basically this suspension has Michael Sherling's fingerprints all over it. It's a cop's idea of civil liberties. That's what it is.
John, thank you for what
Everybody
you're
knows who
doing.
Michael
This is-
Sherling is?
Former chief of police, former
Right.
head of the Vermont Department of Public Safety, now head of. But to answer that, I suspect one of the things that's going on here is they had this Title VI complaint that was brought against UVM for not cracking down on anti-Semitism. And I have a suspicion that
That's right.
one of the things that UVM may be up to here is they did this they're doing this to try to inoculate themselves against a Title VI lawsuit. There have been 3 major Title VI lawsuits filed in the last couple of months against UCLA, I mentioned that, against MIT, and against Harvard. But here's an important distinction, except for UCLA, and I probably should have said this at the outset. There's a big difference between Columbia and MIT and Harvard and UVM. UVM's a state university.
Yes.
When you're a state university, all the constitutional protections apply to them. They can't, all the civil liberties. If you're a private university, it's university policy. If they want to have a crackdown, there's no protest, or we're not going to allow certain things to be said. I don't know what other restrictions they might have if they're getting governmental funding or things like
Yeah.
that. But in terms of, are they subject to the constitutional restrictions? The answer to that is no. UVM's a state college. That's a big difference. And I think the idiots at UVM kind of forgot that. I think they saw Dartmouth doing this, and Columbia doing this, and MIT doing this, and Harvard doing this, and they forgot, hey, we're a state university. First Amendment applies.
Thank you for what you are doing.
Thank you for what you're doing.
Wafik?
Yes, thank you again. I think the elephant in the room on the UVM institution and across the countries on the universities, including the Department of Education, is not the action of the students, because other organizations did the same actions and they didn't get the same response. It is the changing of definition of anti-Semitism. And this is the elephant in the room. And they are trying on the Department of Education in Vermont and Anti-Defamation League and other organization. They wrote a letter for the Department of Education that any criticism of State of Israel, any mentioning negatively to Zionism, it is considered anti-Semitism and anti-Jewish. And this is the major principle. The other thing for freedom of speech across the country, we have 32 states through executive orders or state state representative voted to make our action of divestment sanctions as illegal. And this is too against the freedom of speech. I can boycott Starbucks because they didn't welcome 3 black customers and they kicked them out, but I cannot boycott Starbucks because they are supporting the Israeli.
Yeah, boycotting is protected First Amendment activity.
Yeah. Thank you.
I wanted to just.
Anyone else? Steve?
Did the students make any demands at all, or was it just they were just
There were
presence?
demands. They had some demands, and they had demands about divestment and disclosure, and then there was a demand about the commencement speaker, who was the UN UVM secretary, who decided not to come, and then after that happened, plus classes were ending and people were leaving, and that kind of the wind was out of their sails, so they decided to voluntarily end it. What I wanted to read. You want to talk about the double standard? This is the case. College Republicans at San Francisco State University versus Reed. It was decided in 2007. The holding was college Republicans could not be suspended as a student organization for at a rally desecrating Hamas and Hezbollah flags with the word Allah written on them in Arabic script. It reasoned that unpopular speech was not only protected, but its protection was essential to the First Amendment. The university's laudable interest in promoting civil discourse on campus from time to time comes in direct conflict with the First Amendment rights, which entitle people in some settings to express themselves in unreasoned, disrespectful, and intensely emotional ways. Thus, a student might simultaneously behave in a manner that is patently inconsistent with its civility goals, but that is protected under the First Amendment. And then it goes on to say there are very important differences between primary and secondary schools on one hand and colleges and universities on the other. Colleges and university students are not children, are by law emancipated and can vote. First Amendment protection should not apply with less force on college campuses than in the community at large. Federal courts have enjoined regulations in colleges and universities which purport to prohibit acts of intolerance. And then it goes on to talk about how they have a higher duty under the First Amendment to protect unpopular notions. And then I cite, my favorite, Vermont Supreme Court in a number of cases called State versus Tracy, 2015, which said that this is a very important case. They said the same thing about offensive speech. They said, this is citing the flag desecration and the fundamentalist church picketing a soldier's funeral with highly inflammatory signs.
Right.
It held that it is the provocative nature of speech, which is the very reason it is constitutionally protective. Offensiveness is not enough to fall outside of free speech. It must be so inflammatory so that it is akin to dropping a match into a pool of gasoline. That's the standard under the Vermont Supreme Court, to have so-called fighting word speech not be protected by the First Amendment. So this is all, you're exactly right, this is all what it's up to. They did this, they tried this in the Brandeis complaint against UVM, which was never even investigated. They never even talked to anybody. That was just complete BS job, but that's what they're trying to do, yeah. And the argument is that, yeah, that if you're critical of Israel, critical of Zionism, you violated Title VI, and the universities need to shut that up. And that's right out of Elise Stefanik's playbook. That's what she's saying. That's exactly what she's saying. It's not a distinction. Of course, if anybody with a half a notion of the history of the evolution of Zionism, particularly in the 19th century, knows nothing's further from the truth than that.
When will the university have to respond to this?
Right away.
Or-
Oh, crap. God only knows. That
I thought,
in
don't they have
theory, they're supposed to be responding to, I thought we'd have a hearing
20
by
days,
now,
yeah.
because it's a request for preliminary injunctive relief. Ordinarily, the response to the memorandum, the motion for the injunction, would be 14 days, which will be Wednesday or Thursday. And then their time to file a formal answer would be about a week after that. But I'm and I don't know what Judge Sessions is doing. He may be waiting to see the university's response before he does anything, before he holds a hearing, or what have you. But
But you didn't explain what the preliminary injunction.
preliminary injunction means what we're asking for,
Reinstate.
ending the defendant's May 1st, 2024 interim suspension of its status as a UVM organization pending the resolution of this litigation. While the court case is on, they're reinstated. That's what we're
But
asking.
I still don't understand, how do you suspend an organization?
You don't let them function on campus.
No,
They
I
can't
know that,
meet.
but for
You know what they
what
did in the Healy
reason?
case? They arrested them for having, SDS for having a meeting in a coffee shop on campus.
They arrested the members, they don't, right?
Well, I guess that this, so that's what I'm saying, and I'd be curious, what did specifically, I mean, I know you read us
Yeah.
the language, but were there specific things that the university alleged that the group did that violated, or did they just said it?
All under investigation.
Right.
It's preliminary. We've
It
heard.
wasn't that they slept overnight in the tents, they didn't allege that, they just said you violated this policy that we have, and so
It's
you're.
content-based, obviously, correct?
It's totally, it's total bullshit.
What,
Yeah.
Arena?
Are there students that are suspended also now, or is it just the organization?
There have been no students that have been suspended.
So any student that was camped out there last year, if they were still in school, they're back. They're not.
They tried to bring individual charges against them. They couldn't prove it because they didn't have anybody to say this. We saw this person go into 10 at 10 and come out. Who was gonna? What are you gonna? You're gonna give a whole, sit Shiva out in front of the tent to see if somebody is sleeping there? I mean, that's how their case fell apart.
So this is strictly about
Oh, wait,
an
there's a-
organization. It doesn't involve individual students or their
There's a
suspension.
footnote to
That's
this.
what's so curious.
Footnote this. Michael Shirley now wants an appropriation of the university budget to hire private
Sleepers?
investigators to be investigating and bring charges for student protests so these kinds of exonerations don't
Wait a
happen in
minute,
the
that's
future.
important. Sherling wants what? They want special
They
police?
they just laid off a whole bunch of health workers, but he wants to hire special investigators now. They have on call to investigate student activities so they can maintain these charges against individual students in the future. He said that this was a catastrophe because the people that they had from the university, Lena Holcomb and Jerome Balcom, didn't know what they were doing and doing an investigation because they weren't trained, which is probably true. I mean, if you're not trained forensically about how to present a case, you're not going to know what to do, But they as far as we know, every single student who was individually charged was found not responsible, especially including Logan Pruitt, who is the major spokesperson for SJP. And he went in and
So what are the
clear.
reasons that they suspend this group? What? What did they say?
it's obvious.
Nothing, no reason.
It's obvious.
Right.
Because they were advocating for the Palestinians, because it's verboten speech.
But they don't say it.
Of course they never say it.
Okay.
Well, Bull Connor did say if you march, I'll march you to jail, but that's not how this is practiced. Time-honored position is that we have all these ostensibly neutral things, and it's just you didn't follow the bureaucratic thing, and now we have to enforce against you. That's what this is all about. This is all this is. This is old as time. This is as old as time. The Shuttlesworth case said this is as old as time.
Steve again, I'm sorry.
I just have a quick question.
This
Is
is
your
Arena
filing public record, and how can people get a copy of it?
How can you, oh boy, well, I don't know what, this is federal court. I don't know what the access is to, they have a thing called PACER, P-A-C-E-R. You have to ask the court clerk about that. You may have to go up there and go on their computer.
What do you want a copy of?
Of the filing, I'm going to read it.
I've got one right here, I mean.
No. You want to, if you why don't you do this? Send somebody, maybe Sandy, a portal, a contact to send. I can send you the stuff. I've got it all electronically. I mean, it's this. I am, even though I was born in the Truman administration, I am somewhat conversant in electronic world, and I can send this stuff out. I have it as a PDF. All this stuff is a PDF. I do this because I'm old school and I like to have.
I could have Tim
Paper
down
in
there
hand.
do that. Or-
Yeah.
Right? Ian?
Yeah, so since 2017, there have been a number of cases of students not being sanctioned for participating in protests, and those were listed. You listed many of them. Actually, it reminds me in 1991, there were temporary structures erected on the university green and they were designated as Diversity University.
Right. I remember,
I don't remember what the outcome was. But this issue of the calculus that is made in determining whether an organization would be sanctioned or not is, I think there is a calculus here being made by the university that they don't want protests, but as you were pointing out, some protests are taboo and others are not. And so, you know, this is becoming very, very evident that this is a really fundamental issue. I mean, in the same way as the Democratic Party apparently is making a calculus that by supporting Israel, they're going to lose some votes, and they're going to not lose some votes. But this calculation has been made that it's apparently at an electoral level, it's worth continuing to support Israel, even though it's going to cost them, but the costs will be less than the benefits.
Well, I also
Apparently,
think
I don't understand that.
I think the university has clearly been pressured by probably trustees and alumni. I mean, the suspension of the poet in October on the basis of nothing, totally nothing. I mean, that's I think even a more graphic display of what's going on here. We mentioned that. We mentioned the shooting on South Prospect Street,
Right.
which occurred a block and a half from my house on Thanksgiving weekend. I mean, all that. So it's all part of the climate. And, you know, I mean, you think about it, and some of these protests that occurred earlier where Black Lives Matter participated. Do you think UVM would dare
No.
in a million years to suspend Black Lives Matter on campus? It would be hell to pay. I mean, it would be hell to pay. They wouldn't dare to suspend Me Too. They wouldn't just dare to suspend climate change activists. They just wouldn't dare do it. But SJP, it's different. It's different.
Steve again.
So this is about an organization, though. No student, you're not alleging a student's rights have been violated. This is an organization's rights?
But if you're a member of the organization, you can't.
What would prevent them from just calling the organization something else and reforming again and
Because
going to do whatever they want to
They would
do?
claim it's a sham and that it's really SJP, and they would bring a disciplinary. That has been discussed, and
But couldn't you,
we're not going to do that.
could you
That's not the
argue,
remedy. The remedy is to take this on head on. One of the things we did, they had a protest right when school started, and they had one of them out in front of the Royal Tyler Theater. And I said, look, you got to be very careful. You can talk about the investigation. You can talk about the lawsuit. You can talk about how it's unconstitutional. If you want to do anything broader than that, go out on the sidewalk in front of Waterman. The sidewalk's owned by the city of Burlington, not by UVM. Do it there.
I think one of the reasons this isn't moving fast is because it actually isn't affecting the rights of an individual.
Oh, no, it absolutely is. They're self-censorship big time with this organization. Can't organize, you got freshmen coming in, can't reach out, can't organize, can't recruit, can't do any of that.
The organization cannot.
Right. Well, who are
Not
the
on
individuals going to
campus.
recruit to? Yeah. Stephen, it's the right to associate. It's the right
That's
to.
right,
It's the
right,
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 the
right,
fundamental
right,
right
right.
to associate.
right,
We are the young Democrats. We are the young Republicans. We are the young this. We're the young that. We're students for this. We are the Peace and Justice Coalition. You know, that's fundamental First Amendment right.
so are you arguing that, the freedom to associate?
Of course.
Because they can't join this group, nobody. Because it's not on campus anymore.
So it's banned. It has no presence.
It's as if they were a political party banned by a Latin American junta. The only difference is they're not shooting them and throwing their bodies in the ocean.
Not yet.
Not yet.
So you keep referring to SJP, and you keep referring to Title VI. Could you explain what those are?
SJP is simply Students for Justice in Palestine. It's the acronym for UVM Students for Justice in Palestine.
That's the organization.
That's the organization. UVM I use the term in the lawsuit UVM SJP, but they use the shorthand SJP. Title VI is, I don't pretend to know a lot about it, but Title VI is a statute that says that there's Title VI and Title IX. If you're getting federal money, there's certain things that you're required to do to prevent certain bad things from happening on your campus, and one of them is discriminating against people on the basis of religion. And that's what the pro-Israeli advocates have been using to try to get the Department of Education, and they tried it in UVM's case to crack down on advocacy, Palestinian advocacy, claiming that
What
it's.
are they arguing about that?
They're arguing, what you said is that criticism of, any criticism of Israel or Zionism is per force anti-Semitic. It's an inherent part of the religion, and therefore it's anti-religious and therefore covered by Title VI. Of course, how that's going to come in direct conflict with the First Amendment is.
Right. Don't you have
But the problem is most schools aren't state universities. Now, I think there's some, I don't know about the case law in there about whether they've got to adhere to First Amendment things in order to get the money. I don't know that, but that doesn't bother Elise Stefanik at all. That's what she's been doing. That's exactly what she's been up to. And, by the way, University of Vermont has a long history of this kind of crap.
Right.
I forgot the guy's name, there was a professor at UVM in the 1950s who argued for the recognition of the People's Republic of China. Of course, he was a communist sympathizer. He was out. When I went to UVM, there was a very big anti-Vietnam War activist, Michael Parenti, who taught political science, and they canned him.
Bob Rice. A lot of professors were canned on that.
He ran, as a footnote, he ran for U.S. Senate, U.S. House of Representatives on the Liberty Union ticket in 1974. It blew everybody's minds to get 10 or 12% of the vote statewide. But he went, oh, hey, wait a minute. There's something going on in Vermont. You remember that, Peter?
I remember it, for sure. Peter?
Are other organizations in this? There are other organizations in the city. Members of one of them I know are here in the room, which have no affiliation to the university. Suppose that that organization were to invite some of the students who have been active and to one of their meetings, which could easily be held. I can think of a place quite close to the university that would probably provide space, and they were to invite them there to start to function as part of this non-university organization, and take up the cause of Palestinian support under the auspices of an off-campus, non-university.
But then, if you're an on-campus, if you're an off-campus organization, you can't use the university resources. Can't use university resources to organize. You can't use their whatever web facilities they have. You can't use the Davis Center. You can't use any of that. That's the problem. And Peter, you don't fight this by trying to put on a different hat and sneaking around. You have to confront it head on. You have to say, no, you can't do this. Read goddamn New York Times versus Sullivan versus the United States. What the hell's the matter with you people? That's how you confront it. By the way, it was confronted directly that way in the University of Florida. What's the governor down there? DeSantis. DeSantis said SJP should be outlawed as a terrorist organization. Terrorist organization. SJP in Florida and the Florida Civil Liberties Union brought suit against the Board of Regents of the University of Florida and DeSantis and said that violated the First Amendment, and they backed down and they said, oh, no, we didn't have any plans to take any sanctions. That was just Ron DeSantis spewing off at the mouth, and the U.S. District Court dismissed it. So they've gone after it once. I noticed that now there's a loss. I think Rutgers has brought a lawsuit.
I thought Maryland, but
Maybe it's Maryland. Rutgers didn't bring the lawsuit. Here's another one which is really disturbing with me.
It's a great answer, by the way, and yes.
University of Michigan.
By the horns, right.
University of Michigan. They're a state university. They had an encampment out on the green. And the University of Michigan, sending the goons, tore down the tents, did their thing with mace and billy clubs and tear gas and injured people, sent 3 people in the hospital. You know what their justification was for eliminating this tent? You ready? A fire hazard because people were cooking on hibachis and little gas grills. And my immediate reaction was, oh, the next time the University of Michigan football team has a home game like they had this weekend, and they have 100,000 people there, and they're tailgating out in the parking lot, bring in the Marines. fire hazard, right? I mean, the level of what's the word I'm thinking of? It's not even hypocrisy. It's not even good. It's not even a good justification. The word is escaping me. It's like mendacity. The level of mendacity for this. I mean, it's like that. You know that Allstate ad where the guy shows up late for the game and hits all the cards. Mayhem guy.
Right. I love
It's like,
that.
yep, we got to bring in. Who is it? The governor of New Hampshire, Sununu. That's what he did at Dartmouth. He came in and brought in the goons.
Busa,
Is there
do you need a mic?
Extend that.
Mike? This is happening across the country, you know, in all universities.
Yes.
Is there coordination? We are lucky to have you to do a lawsuit. Is there coordination with other lawyers across the country? And the reason I'm asking, there is one organization that can be helpful, is Palestine Legal.
They have a great website. Yes. I'm
Mm-hmm.
familiar with
Yeah,
it. Yes.
also they offer resources.
Yes.
Yeah.
The SJP in Burlington has been in contact with national sources.
So is there coordination between you and other lawyers across the country?
There isn't even a coordination internally with us yet. So one thing would step
But
at a
there
time.
will be, maybe.
There will be.
I hope so.
But there's also another necessity, which is funds. I'm just mentioning that
You need
because
to put it.
lawsuits.
Somebody's going to put up a GoFundMe
Yeah,
page.
somebody,
You need a GoFundMe.
we
page.
need donations to this, court
So
costs.
we should fund. I mean,
Yes.
Do it on.
Yes.
Somebody set up a GoFundMe page to do the.
Well, I don't,
to-
or send checks
Somebody
to
needs to,
John
who knows how
Franco.
to do that, needs to do that so that we can raise funds for this lawsuit.
because this is really happening.
Everywhere.
It's a war that is coming at us, and it has to be coordinated effort, you know, to battle it back. And I hope there will be coordination. And if we need to fundraise, we should be doing that.
Right. If anybody watch, a lot of people probably do watch Amy Goodman. She went through it like a week ago, all the censorship that's occurring on campuses.
It's everywhere.
It's everywhere. Well, it's not in the little colleges that don't have mass donors. It's at the schools which have a lot of donations from rich and powerful people who support Israel's cause.
But that's coordinated. You know,
Yes, yes, I agree.
ADL
I agree.
and all of these donors, they are pressuring
true.
all of these
Right.
universities.
I want to tell you a story. This is Old Age Week, 1972 Yom Kippur War. I was at UVM Billings Center, and the Jewish Defense League was there. I don't even know that's even in existence anymore. And they were claiming at that time is exactly the same thing, that any criticism of Israel
They always
was
proclaimed it.
anti-Semitic.
Right.
And that was what they were, that was the loud and strong, that was their argument back then. That was 52 years ago, you know, so.
Oh yeah, this has been going on for a long time.
Eric, back there?
Yes.
Do you want it, Eric?
Oh, here. Does it reach?
My first question was, I don't know if it was partially answered, but if it was a private university,
Right.
would you tackle the issue differently?
I don't know if you could tackle the
You
issue.
can't.
I don't know. I don't know the answer to that. I don't know if you could tackle it. You might have to try to do it through Title VII, Title VI, I mean, but you wouldn't have the same, all this stuff, all this case law, all that. It doesn't apply. That's why, you know, when I saw this suspension, my first reaction was, how could UVM be so stupid? And which is why I wanted to sit down with them in the summer and say, how could you be so stupid? You know, they're away now. They're going to come back. The university president is leaving. He's going to Arizona, turn over a new leaf. Nope. Which is why I think that they're hedging their bets here. I think the university feels they're in a no-lose situation. If they lose this lawsuit, then they've inoculated themselves against the Title VI claim. That's a private theory that I have, but I think that may be
You're
what's
probably
going on.
right, though.
So they're going like, hey, fine, sue us. I'm glad you did.
Second question will, pull us a little bit out of, the universities and see the country, as a whole, like, do you think that the problem on the university are, a symptom of a bigger problem in this country where, the justice system is losing any credibility?
No.
Is it? No.
No, but wait a minute.
Because the past years, I see people bragging about choosing a Supreme Court, personality. I mean, a student in law would be, really baffled by all this,
I think, though, that
Not if you study the history of the U.S. Supreme Court. That's not baffling at all.
Yeah, but I think what he's trying to say is that we're not necessarily talking about the justice system right now. What we're talking about is universities across this country are censoring pro-Palestinian, end the war protests. Those are universities. We don't really know what's going to happen in the courts. So this case tonight is against the university, and we're hoping that the courts will be fair. Now, whether or not they're fair is going to be a different matter. But he cited many cases, Eric, that do protect free speech. For instance, when you're talking about desecrating the flag, when I was in the legislature, there were constant attempts to make flag burning outlawed. However, it wasn't ever outlawed because the Supreme Court said that you can desecrate the flag. This is free speech. So the courts have often protected free speech. But right now, the threat is from the universities that are censoring everything. Everybody's censoring everything, including the media, too. And it's all about Palestine.
Yep.
But it's not necessarily the universities only. If you look around the country, I mean, states. We mentioned the name of like a governor of a southern country. I mean, Florida. There's so much. Does it mean that something is failing? Because for someone to be able to suspend a student or a student organization so bluntly, it means that they are being invigorating by, something that's going on. Either the political situation, because I wanted to see the link between, the political, atmosphere and all this.
Bet your bottom dollar that threats were made that if something wasn't done about this, certain donations wouldn't be forthcoming anymore.
That's what
That's exactly what the name of the game is. That's don't even need a.
These universities are funded by donations by rich people.
But is it also a problem that education be only under donations?
No.
Is there any constitutional right to education, for example?
No.
Not
at university level, no.
Not on university level.
Can we be proud of being a nation that doesn't have and then be surprised that,
there's a lot of,
or whatever security guard on
there's a lot of reasons not to be proud of the United States, but there's a lot of reasons to be proud of the United States. The main one to me is the Bill of Rights.
I heard many elements on the case from you tonight, but I didn't hear about the practice UVM through the 10 days, what they did. I mean, there is an element that says the UVM are suspending the club. The reason because they were afraid of something bad will happen, that the club or the members of the club, their intention is to do harm to the property or whatever activism. But I didn't hear the opposite, like through the 10 days, what UVM did to the students. The harm inflicted by the institution by putting highlights, cameras in every corner, intimidation, scaring many students, mainly Palestinian origin students and Arab students, Muslim students who are in F1 visa, who are not American, that they couldn't join the activism of the Student for Justice in Palestine. They were trying their best to show solidarity, but at the same time to stay on the sideline because they will lose their status. The intimidation by the chief of police, coming again and again with the threats. And the history of the chief of police, by the way, he is trained on Israel with the deadly exchange. His name is existed. He sold and became salesman for software for many institutions, practically to spy on an institution that made in Israel, product made in Israel. And he came back later to become a chief of police.
In Burlington, you're
again,
talking about?
for the second time.
Wait,
you
wait,
know?
wait. Could I ask, are you referring to Michael Sherling, head of security at
Yes.
UV? Okay, not Murad.
No.
Sherling,
The chief
okay.
of police of UVM.
Okay, right.
And not only him, he went on the trips invited by the IDF and others.
Wow.
The chief of police before him, she was a woman. She went on the same trip, which is a training trip
Right.
to, yeah.
Well,
So
that's an interesting
there
piece.
is a lot of harm happened to our students on the campus, that didn't happen on the private colleges in Vermont, like Middlebury or Sterling, As a matter of fact, the only opposition in Middlebury from the campus administration was you cannot make the Green as alternative university as the students intended, because they invited speaker after speaker to educate the public about labor struggle, student struggle, liberation movement around the world. This is what they opposed to. But in general, they didn't suspend them. They didn't threaten of suspending them.
Well, you got to understand though, when I have a lawsuit like this, it can't be a stew of stuff. We've got to focus on the harm to the plaintiffs, which are these students. So what was the harm to them? We do talk about what you're talking about it's called a chilling effect. That's the legal term.
Chills.
It chills. It makes people fearful of associating with. We put that right in the front of the. I'll tell you what I wrote. The very first paragraph. In a word, as a state university, the defendants have invoked state power to muzzle UVM SJP, to delegitimize it, and give anyone else second thoughts about associating with it, which is exactly what you've just talked about. And that's exactly what they were up to. And the students talked about this. Oh, that was the other absurdity. We brought that out in the suit too. They had this thing, and it was this camera. It was a security camera, and they were doing security. They're saying, it's like now 4 months later, 5 months later, they haven't done an investigation. They had this damn camera on for 10 days. They don't have evidence of an investigation of what went on there? I mean, come on. It's all baloney.
Can you subpoena anything they have
Sure.
done?
Yeah.
Yes.
Yes.
Fundraise.
Yeah, but you're talking about, I have limited time and resources. I'm not a 50-person law firm here. This isn't like.
That's why coordination is really important.
Well, that's why fundraising in this thing is going to be really important, because I haven't even got what the UVM's going to throw at us yet. That's going to happen in a week or two.
Okay, this should be an ongoing effort, but, we're reaching the time limit, and so maybe we'll take one other question from Ian. But wait a minute, I just want to say one other thing. I mean it about fundraising. I know what it costs to do a lawsuit. This is going to be a nationally known lawsuit. It has to be done correctly. John Franco is a single practitioner, so please think about donating your time and money to his law firm.
You need to set up a website,
But I don't know how to
GoFundMe
do that.
page
Does
to do
anybody know how to do
You have
that?
to recruit somebody.
What?
You have to recruit somebody who knows how.
I know, so, okay, hey, Tim, can you do it? Okay, this is my assistant, Tim Galloway.
It's going to happen.
Can you really do, okay, we
You've
need
gotta
to
you've
try
gotta
to do
it
that
online.
tomorrow,
You've gotta do it
okay?
online.
All right.
And then what happens is, then you set up a fund where that collects the money, and then the money. Somebody said, "Why don't I do it?"
No,
No way.
and not me either. But we have to also do events like this. Hey, but how about Kalia too? Kalia's I'm hoping, Kalia Livingston back there might be our 4-year clerk in my office. Anyway, Kalia is a very bright, intelligent young woman who I hope will become a lawyer. Anyway, Musa.
I just want to stress, this is a coordinated effort
Right.
across the country, attacking all universities, and you see their excuses, safety and all of that. It's all being fed by somebody, by some source.
It's a playbook. It's nothing.
Is a playbook.
It's a playbook.
But we really, like Palestine Legal, I hope somebody can reach out because they are connected across the country.
It's already happened.
It's trying to,
Yeah.
yeah, I really hope, because it's coordinated effort and we have to have a coordinated effort back. And thank you, you are in the spearhead of this effort.
He is.
Yeah?
I think his is the first lawsuit that has been filed. Is that correct?
No, University of Florida was the first one.
Was the first one?
What's the
Okay.
first one?
They're fighting.
Anyway,
But what's been disappointing is like they suspended SJP again, and I think
Where?
at Rutgers, and they didn't do anything about it.
Well, we're going to do something about it.
anyway, thank you.
Okay, so with that, his office is 110 Main Street, 05401. So send checks, okay?
No,
Anyway.
don't send them. Set up a fund and have the funds send
Okay,
me the
all
check.
right, okay.
Don't do this ad hoc, Sandy.
All right, please, I just got Tim to
So
do it.
I'm Ian Stokes, and I maintain the website for Vermonters for Justice in Palestine. It's vtjp.org. And there's a panel right at the top of the main page, which is about this case, and it gives information about how to donate to a legal support fund for the case.
We need something more more concrete.
No,
than
we
that. You
did,
need-
Tim just said he would do a
Okay,
GoFundMe, right?
you need to do a GoFundMe page, and you need to organize you need to really get the message out at UVM, you get among the faculty, among the staff. I mean, a lot of the things that went on there were the staff unions that came in and organized and protested and spoke. They said, "Oh well, this isn't really a public forum." Well, outside the Davis Center, they have an outside stage. Literally a stage that overlooks the green, where people. That's where a lot of these protests and speeches were held. It's just.
Can I say one other word? I also want to thank the law school. Jared Carter is a professor at this great new law space at Vermont Law School, which now has a Burlington space, which is this space. Its main school is in South Royalton. Jared was the person who was able to arrange the use of this space, so I want to thank him and the law school for hosting this. Remember that this is a free speech place, and I believe that is, and the new president of Vermont Law School gave a great presentation. I guess Grant saw that at the Enrichment Education Series, in which he pledged that Vermont Law School would be a center for free speech activities and respect for the First Amendment. That's very unusual these days. And
issued a major email release
Right.
September 19th. He didn't mention us in substance, but in substance supporting our position here.
so we'll thank the law school and Jared also.
Yeah.
I think that's really important to say, to UVM, we got VLS in our, I don't call it VLS anymore, VL and what?
VLGS, and I think the heart of what the law school has said, it really gets to those critical and fundamental components of the First Amendment, which is to protect speech regardless of the message, regardless of the content. And while private institutions like Vermont Law School don't have to comply with the First Amendment, when they internally take that position, I think it sends a really powerful message about what the values are.
I got to tell you, I went to UVM during the anti-war movement, and I'm like, when Ed Andrews was president, he was a physician, and poor Ed Andrews, he was from Plainfield, Vermont, and at that time we called him a fascist. Oh, good God, he was not.
Who's that?
Ed Andrews was the UVM president. We could protest, we did everything. They didn't care as long as we weren't burning the campus down. They left us alone.
There were quite a few occupies though, weren't there?
Not in
Well,
my.
there was
not in-
one in solidarity with South Africa, remember that?
Not when I went there.
But-
That was
well, not when
well
you
after
went there,
when I
but
went there.
later. Okay, so
you.
if anybody gets in trouble with all these protests, you can call me. Yeah, thank you.